SJC-13671, 480 McClellan, LLC versus Board of Assessors of City of Boston.
Okay, Attorney Albano.
May it please the court, my name is John Albano. I'm here on behalf of the appellant 480 McClellan, LLC. With me are my colleagues Matt Schnall and Andrew Bottaro. With the court's permission, I'd like to address the following 3 points. First, whether the board erred by holding that the for-profit nature of the appellant compelled the conclusion that the lease was for a business purpose under the original language of Section 17 of the Enabling Act. Second, whether the board erred by refusing to consider whether the property also was exempt from taxation under Chapter 59, Section 2B. And finally, whether the board erred by holding that the 1993 amendment to the Enabling Act never took effect, despite the provision of the Massachusetts Constitution that a bill vetoed by the governor, quote, shall have the force of law, close quote, if upon reconsideration of the vetoed bill, 2/3 of both houses approve the legislation. Turning first to Section 17, again, the original language of Section 17 provides that no property of the authority shall be taxed, essentially, unless it is leased for business purposes. What the board did was base its decision that Section 17 did not apply on the fact that the appellant is a for-profit business. But I'd suggest that was wrong for a couple of reasons. First, the legislature has consistently distinguished between two distinct concepts in this area. Is a business for profit on the one hand, and on the other hand, is the lease or occupation for a public purpose. That distinction is made in Chapter 59, Section 2B. That distinction also is made in its statutory predecessor, Section 3A, and in the appeals court decision in Beacon South Station Associates versus the Board of Assessors of Boston. That distinction also was brought home because in that case, the court was applying a public purpose exemption, and it noted that after the years at issue, the legislation had changed and added that if you're a for-profit business, it's taxable. And the court said that's a narrowing of the exemption from taxes. And the same point was made in this court's, it wasn't the heart of the case, but the same point was made in the court's out front media case earlier this year. So there is this recognized distinction between a for-profit business and a business that's serving a public purpose. And yet the board here just conflated the two and said, you're for-profit, we're done, you're taxable. The record, though, the record is that Massport was on record as saying this lease was essential to the functioning of Massport, its governmental functions. The lease itself, in permitted uses, has a list that makes it very clear. There's things like you need to have an intermodal freight office and warehousing, receipt storage, preparation for shipment of marine, air, domestic, and international cargo. So I would suggest that this record demonstrates, and there's really no evidence to the contrary.
Well, isn't the record is a little bit unclear, right? Because there's reference to office space, but it doesn't say, what office space. Like it could be rented to a candy company for all we know on this record. Is that right?
That's a fair point. The record does not detail what the office space is, so as I stand here, I can't tell you that office space was for people who are organizing freight shipments and cargo. That is not part of the record. But I will say that the record that was before the board does not support a decision that simply because the company is for profit, analysis ends and it's not leased, and it's been leased for business purposes.
What happens if, hypothetically, this were sent back and for further proceedings, and what if the property is being used both for public purposes and for non-public purposes?
I would suggest that the decision should be what is the primary use of the property. That if it is primarily, occupying the property, that if it is primarily for a public purpose, but yes, there's some private business as well, that the exemption would apply. That should be the analysis of the board in this court. What's the heart of this transaction?
Can I ask you why this distinction between business, or why does business purpose require us to look to whether there's also a public purpose? The board seemed to equate business purpose to for-profit. And you're saying we have to import into the word business purpose in Section 19 the idea of whether it's a business for profit for public purposes.
Yes.
Why? Because it seems to me Section 2B actually has that language in it, whereas Section 17 does not have that language.
I would suggest that 2B is really quite consistent and complementary with, if that's the right term, with Section 17. It articulates a specific example of what would not be a business purpose. And I would also say that the court in not out front, it's appeals court predecessor, the Beacon South Station case, really did draw this distinction of what is it a public purpose? And that historically is what has exempted property from taxation.
But just stick with me with the language of the statute. Section 2B says business conducted for profit other than public purposes, right? And Section 17 just says leased for business purposes. And it seems to me that when there's different language used, it's for a reason. And you're saying, no, business purposes in Section 17 means business conducted for profit other than public purposes.
Or nonprofit for public purposes. Yes,
But wouldn't the legislature have said in Section 17 something to the effect, if leased for business purposes other than for public purposes?
I think not, because if you step back,
Yeah.
what's going on here is we're talking about publicly owned property. And of course, if it was just Massport, it wouldn't be taxed. And so the legislature is saying, okay, when will this use of publicly owned property be taxable? And if it's for primarily a business purpose, then why should my law firm not have to pay real estate taxes when the law firm across the street does? That's primarily, and there's a notion of this in the cases. If a business is taking advantage of the exemption just for a business purpose, as opposed to what the cases talk about in these tax exemption, if it's for a public purpose.
But those cases, and I haven't looked at them, you're more familiar than I am, are those about Section 2B or 3A? Or are they about the specific enabling act for Massport?
The ones I'm thinking of are really talking about the history before both of what what types of property are not subject to taxation because they are serving primarily a public purpose.
So those cases don't deal with any of the things that we have before us?
Well, I would suggest they do bear on the issue because.
But they're
the
not Section 2B cases?
Section 2B cases concern more specifically the language of Section 2B, although, I mean, I
can look it
I
up.
don't want to guess, but
So can I ask you pivot for a second? So Section 17 says, no property of the authority shall be taxed to a lessee, your client, under Section 3A, now 2B.
Right.
Instead, it goes on to provide, it shall be taxed if it's used for business purposes.
Right.
So why would we look to Section 3A or 2B to figure out the meaning of Section 17?
Because that very language is simply saying you can't look at 2B, 3A
Yeah.
to tax this property.
Right,
And
including the language in 2B that says, businesses conducted for profit other than public purposes, right?
Yes, but my point is this, Your Honor, that all that language says is you don't get to look to 2B to impose any taxes on this leased property. I'm not doing that. I'm looking to 2B not to tax a lessee,
But to inform the meaning of business purposes.
but, well, and to say that language of 2B, particularly the last paragraph, which now says the section shall not apply to a use, lease, or occupancy which is reasonably necessary to the public purpose of a public airport, is totally consistent with 17, because Section 17 merely says, thou shalt not look at 2B to impose a tax. I'm not. I'm looking at 2B to say, 2B says it is not taxable.
Can I ask a different question about the interplay between the statutes? I think a strange result of not interpreting business purposes the way that you want to would be that Massport Airport's port would be treated less favorably than all other airports and ports because they get the benefit of the 2B treatment, and anyone who's on Massport land would not. But Massport's already being treated differently. Massport properties are already being treated differently than other properties because Section 17 was amended to include payment in lieu of tax provisions. So what's your response to that argument that actually Massport is being treated differently here and for good reason and very intentionally by the legislature?
I think the response to that is simply, I'm sorry if I'm being narrow-minded, but I'm just trying to follow what the statute says. And the statute has these provisions that say when that property shall not be taxed. And I don't think the legislature is required to tie that language to whether payments in lieu of taxes are offset or not, or are we treating Massport better than the Mass Turnpike, but simply what did the legislature say? And I'd suggest they said this property should not be taxed. See my time's run out. Could I, if I may, just quickly get to the...
You still got green, so
Sorry?
you're still on green, so go ahead.
Okay, I'm colorblind. So
Okay. Oh.
Whether the amendment to the Enabling Act was effective or not. And I would suggest there that you have a clear constitutional provision that says once that 2/3 vote override occurs, the law, what's the language? The legislation shall have the force of law. And yes, the court defers to legislative rules. But the constitutional provision there, Part 2, Chapter 1, Section 1, Article 4, says after, yes, the general court has these powers, wholesome and reasonable orders, concludes by saying, so as the same be not repugnant or contrary to this Constitution. And I say two things here. Well, let me just say this before I sit down. A, if the internal rules of the Senate provided that one member filing a motion for reconsideration trumps the clear language of the Constitution, I would say that does not withstand scrutiny. And last thing I'll say is that rule doesn't even say that. That rule on motions for reconsideration does not say that, oh, by the way, and if one senator files a motion for reconsideration and we never take it up, veto override goes out the window.
If we were to agree with you on this parliamentary issue that you're raising, would the case then be remanded for determination under the amended Section 17?
I would suggest that the
We don't make facts, we don't find facts here.
right.
So where would the determination as to what happens,
So
what happens next if we agree with you on the parliamentary question?
there are only two possibilities, right? I would suggest that the court does have discretion to say if that 1993 amendment is valid, and the only issue is, was the property used for air transportation purposes, then the record before the board shows that it was. If that is not, of course, if the court is not satisfied that the record demonstrates that, then yes, I agree, a remand would be needed.
Could I ask one question? I don't think you've had a chance to respond to the Massport amicus brief in writing. Do you want to say anything about Massport's arguments, particularly a number of different laws they've identified, or putative laws they've identified where a similar procedure took place, it appears? I haven't looked through all the legislative history myself, but what they report is that there are a whole host of laws or bills that were passed, including Section 109, if I might be getting that number wrong, but another amendment that would actually be problematic for your client.
So the thing I thought I should respond to in the amicus brief is the citations to the two opinion of the justices cases, one in 1956 that cites a 1935 one. And in those cases, a motion for reconsideration did the trick that they wanted to do here. I would just say those cases are quite different for two reasons. First of all, both courts said, well, this was a joint session, and joint sessions don't have regular assemblies, and therefore I hate to, well, I'll paraphrase, I don't want to get it wrong, but therefore, the first vote didn't count. This is not a motion for reconsideration that could be taken up at a regular assembly, and suggested that if that weren't the case, then the motion for reconsideration never taken up dies. And the last thing I'd say about that is that in neither of those cases was that effect of a motion for reconsideration to undo legislation that a constitutional provision requires have the force of law. So they don't control here. And if my memory's right, there's been no citation by the amicus of, oh, here are the many cases where vetoes were overridden, but a motion for reconsideration did them in, and therefore the world will crumble. I thought when I saw former Justice Cipher's concurrence in that Lanier case, where she quoted the late Chief Judge Gantz saying, "We don't generally say, well, we rely upon the importance of continuity. So if it was an injustice that occurred a while ago, we're just going to leave it be." I would ask that the fact that the 1993 amendment has been ignored, notwithstanding the clear constitutional provisions, the court should not just let it be. Thank you for, I know I'm.
Did you get your question answered?
Not?
I'm just relying on the Massport brief, but at pages 29 and 30, there's an argument about, that was about an amendment to 59.2b that would have changed 59.2b exemption as well. I take it none of us is, there's an argument in general that there could be sweeping consequences to this court saying that a practice that, at least it's told to us, has occurred in a number of other instances could mean that there are other laws out there that no one knows are laws, and that if we say that this seeming practice is unconstitutional, there are a whole host of laws that may sort of unexpectedly come into being. And so I just wanted you to have a chance to respond to that.
Yeah, I'm sorry. The most I remember from that, well, it's a great brief, but the thing I remember about it is that I didn't recall seeing a list of, here are a bunch of overridden vetoes that got cast aside because there was a motion for reconsideration never taken up. So that's what to me seemed the most important point.
Thank you.
Thank you very much. Okay, Attorney Umbriano?
Good afternoon, Attorney Anthony Ambriano on behalf of the Board of Assessors of Boston. I would like to address Justice Dewar's question briefly. Yes, the Massport brief, the amicus brief, I think hit the nail on the head on that issue, which I did not, but it did. If the court were to accept the procedural analysis offered by McClellan here as to the override and the motion for reconsideration, that precise analysis would also apply to Section 109 in that same bill. Again, vote to override the veto, motions for reconsideration not acted on, in which case the air transportation use provision goes out, and much more property is taxable even than was contemplated. A couple of more things with respect to the...
I mean, I understand that, but I guess I'm still, it doesn't answer the question as to whether the argument is correct or incorrect. The effect of the argument may be sweeping, but that doesn't necessarily mean that the argument is wrong.
Certainly, and I will address that.
Okay, may I ask you specifically to perhaps on that front address the, I'm looking at the Journal of the Senate, which I take it is sort of the official record of the Senate proceedings. Am I correct in that understanding?
That is correct,
Okay.
yes.
So what I'm looking at is the Senate's own record of what happened with the override vote. And it reflects, I think, I'm looking at, in case you want to look at the same thing, page 1315. It says that the yeas and nays having been completed at whatever time it is that they've been completed, and it shows all the names, that 2/3 of the members present, quote, approved the same. And what's hanging me up here is, or what I'm focused on, is that if that is the official record of the Senate and it shows that it approved the override, and we know that the House approved the override as well, why doesn't that exactly track the language of Article 2?
Because I think very important to that analysis, Justice, is this court's decision in K. Jewelers.
Different, opposite set of facts,
I
right? What was the procedure that happened in K. Jewelers?
K. Jewelers was also the question before the court in K. Jewelers.
But I'm asking about the facts.
It was a motion for reconsideration that had not been ultimately acted on, no final action, which, by the way, is the same language.
But what happened before then?
Before that, in K. Jewelers, you're testing my knowledge, right?
It was the opposite of what happened here.
Correct, but I think the fundamental principle enunciated in K. Jewelers is that the Constitution requires that action be taken, and it is referred to as a reconsideration.
Right, we can look at the Article 2, but in K. Jewelers, there was no override vote. That override vote did not pass. And then there was a motion for reconsideration.
Correct.
That's not this situation. We have an override vote that satisfies the requirements of Article 2. And Article 2 then says, once that happens, the bill will have, I think it uses shall, the force of law. If I take all that language at face value, I'm then left wondering how an unacted upon motion for reconsideration, or even an acted upon motion for reconsideration, could override the provision of Article 2.
I think Article 2, by its terms, says that the legislature shall reconsider. And that language does not strip the legislature of its authority to continue to process that bill in accordance with the legislature's own rules and procedures.
Ad
which is what
infinitum,
happened here.
ad infinitum, even after they have reconsidered it. I mean, you can't just, I don't think, take a couple words of Article 2 all by themselves. Because Article 2, and I'm having trouble just pulling it up on my iPad, but I believe that what it says is that the Senate can reconsider, and then, here we go, if after such reconsideration, so the reconsideration comes first, because it says if after such reconsideration, 2/3 of the said Senate or House of Representatives shall, notwithstanding the governor's objections, agree to pass the same, it shall, together with the objections, be sent to the other branch of the legislature, where it shall also be reconsidered, and if approved by 2/3 of the members present, shall have the force of law. I don't see anything in Article 2 that provides for reconsideration subsequent to a 2/3 override vote.
I think that one of the key words, Justice, is the word approval.
Yes, that's why I was, yeah.
Approval denotes in accordance with the legislature's procedures. Now, the last word of the legislature on this is no further action was taken. That's what the Senate records show. And ultimately, the official records of the Secretary of State show the same thing. It shows Section 53 was vetoed. Certain other sections were in fact overridden and took the force of law, but there was no such certification as to Section 17.
This is why I asked you about the Senate record and whether it was the official record, because it says that it was approved.
And it says no further action was taken on the disapproval veto And I direct your attention to Volume 2 of the Record Appendix, page 146.
Okay, but I'm looking at the actual vote, where it says that after the 2/3 of the members present approved the same. It says that that 2/3 of the members present approved it. Why doesn't that end the inquiry?
Because under the Senate rules, a motion for reconsideration was made. That motion for reconsideration was itself considered at least 6 times, and each time that vote on that was postponed. The legislative session ended, which under Article 10 terminates the bill, terminates the life of the bill.
So I take it, your view is that the parliamentary procedures regarding the motion for reconsideration can override Article 2's language that says shall have the force of law.
No, I would not take that interpretation. What I would say is that the word approval in Article 2 is of substantial import. That allows the legislature to process it in accordance with its customary rules and procedures. And I think that is the point of K. Jewelers, even though, yes, factually it was reversed. Nonetheless, the point is that Article 2 does not divest the legislature from the ability to consider further action. That is to, and I use the word consider as using K. Jewelers. Yes, we can consider it the way we consider everything else. And so I think that's the important point there.
In K. Jewelers, the consideration took place before the vote, the override vote.
Yes, but nonetheless, again, this court has traditionally been reluctant to get into the weeds, shall we say, of the legislature's rules. And here, again, the final word of the legislature was no further action was taken. And that was what was certified by the Secretary of State with respect to this provision.
Can you just explain to me procedurally how this would have worked? So there is the 2/3 override, House and Senate, and then there's the motion to reconsider. Then let's just say the next day that motion is taken up, and then what would have happened if it was allowed, the motion to reconsider? Would that then there be another 2/3 vote required, or how does that work?
Well, certainly if the motion to reconsider had been denied, that would be an easier course.
Of course.
What would happen, I would be hesitant to
You don't know.
speculate as to what would have happened, because ultimately, as indicated,
This was
it
continued.
was considered many times, but no vote was ever taken, and eventually that expired. And I go to the opinion of the court, opinion of the justices, that there's no final action taken on legislation unless and until there is a adverse disposition, to use the court's words, of a motion to reconsider. I may switch now a couple of points with respect to the exemption issue. There were some statements on oral argument, and I think from the court as well as counsel, talking about primarily for business purposes and weighing. The word primarily does not appear in Section 17. If it is used for business purposes, it is taxable. The weighing has already been done by the legislature, and that is what has been enacted. With respect to the issue of for-profit business, I think the findings of fact of the Appellate Tax Board, which are final, they don't really turn on for-profit. Of course, it mentions that the that McClellan is a for-profit LLC. But the ATB examined whether it was engaged in business. Well, the for-profit LLC did buy the interest in the ground lease. It did build the building.
But what wouldn't, that's not very convincing, isn't it? Because wouldn't any lessee, I mean, any lessee is not going to lease property unless they have a purpose for it, even if it's a public purpose, even if someone had a very clear let's say call it a nonprofit or charity, right? So a nonprofit or charity is going to have a whole bunch of capital and pay a bunch of money for the property. And so why is it hugely significant?
It has been determined by the legislature if you're conducting a business.
So even if it's a nonprofit,
I think,
what's not a business? Someone has enough money to lease this property. What, in your view, would fall outside quote-unquote business purposes?
it would be very difficult for me to think of an example where an entity pays for a lease, pays for an interest in property, and then subleases it. I can't think of an instance where you might say, well, that really wasn't business. This is, in my view, a somewhat easier question than the one addressed last year in Outfront.
So this is, I mean, it's really peculiar because then what you're left with is an enabling statute for Massport, which as amended says, Massport property is not subject to tax under 3A/2B, but it's basically always subject to tax to its lessees.
Well, in the hands of lessees, I think that is correct, and I think that is the intent, and I think that is the way the ground lease here is structured.
But doesn't the legislature usually use words to have an intended meaning? They wouldn't have said for business purposes unless they intended that to have a function, wouldn't they?
No, I think that is correct, and perhaps there is some example where someone enters into a lease not for a business purpose, but I
mean, this was originally enacted in 1956, and 3A already existed at that point. And the 1951 version of 3A specifically exempted land under the control of, I forget the old name for it, but the airport person and the port person. Now, the 1951 version of 3A already exempted their lessees from tax. Mm-hmm. So then you get this statute creating Massport. Why shouldn't we, notwithstanding that the language used in 17 is sort of almost the inverse of the super awkward 2B language, which is, in connection with a business conducted for profit other than public purposes. So it's like the business and the purposes are segregated, and then they've shorthanded it in 17. Why shouldn't we read the Section 17 language as sort of shorthand?
Well, I think Section 17, by its terms, prevails over any other statute.
I agree with that. I'm just asking about sort of how we understand the term business purposes, which it strikes me should have some sort of meaning.
Well, one could look, and I think the ATB cited it in its decision in this case, another tax case, the Sherwin-Williams case, and said, well, business is generally something undertaken for profit, and contrasted that with the decision of the appeals court in the Mass PCS Co. case, which was a lease situation that had been set up essentially to take advantage of a tax exemption. But I think that ultimately, where there's a specific statute here, I don't think that business purposes can really be contested. And at the appellate tax board level here, McClellan basically said it's either public purpose or business. And public purpose does not appear in Section 17 anywhere. This court in Outfront, in not directly the same situation, but in Outfront, a taxpayer tried to read into the MBTA exemption statute Well, you can't tax us because we're involved in an essential governmental function.
Well, that was very different, because that was running advertisements on billboards, which is very different from here, where you have a letter from Massport saying the facilities of these lessees are essential to our operations.
Well, again, the statute doesn't say essential governmental functions anywhere, and it never has. It's a business for-profit by a for-profit LLC involved in activities, and I think it was pointed out earlier that the ground lease is not in any way limited to air transportation uses, let alone any other public purposes, such that office space will qualify as a permitted use. And there was a question, if I may. I'm like, thank you.
Yeah, I think we're all set.